Good morning, class. Hey, it's Mr. Stewart here. This is going to be the integrity video for Chapter 16. And at this point, you should have already read Chapter 16, and today will be the day that your initial discussion postings are due. So hopefully you have an idea at this point, when you're playing this, of what I'm going to be talking about. So Chapter 16 has to do with the crime scene, chain of custody requirement, and the use of fingerprints and trace evidence. I'm not going to spend a lot of time talking about fingerprints and trace evidence, but I do want to talk for a bit about the crime scene and chain of custody, because those are very important things, especially in regard to getting evidence admitted at trial. You're going to have to make sure that what you've done at the crime scene was in line with proper evidence collection procedures and procedural due process, as well as the whatever the rules of criminal evidence are for the particular state. And it's also important that you have maintained the chain of custody for whatever evidence that you've been able to find. All right. So, obtaining evidence from a crime scene. When a crime scene occurs in a private premise such as a home, apartment, office, or factory, law enforcement officers must often enter with the consent of family and victims. Law enforcement officers may stay in a crime scene for a reasonable period of time to perform whatever tasks they are obligated to do. Now, understand that when you get a call for service and somebody is reporting a crime has been committed, you will probably have the right to go onto the premises initially in order to determine if a crime has been committed. But in order to search that location for evidence other than what may be in plain view at the location of wherever the crime occurred, you are probably going to either have to have consent by the owners of the property or the tenants of the property, or you're going to have to go get a search warrant. And I always will say, when in doubt, secure the scene, leave officers at the scene, and go obtain a search warrant, because then your I's are dotted and your T's are crossed, and whatever you obtain through the course of processing that scene for evidence will more than likely be admissible at trial, because you have a court order to actually go and search that scene for that evidence. Make sure you read this case here, Mincy versus Arizona. The court held that law enforcement officers may make warrantless entries and searches when they reasonably believe that a person within is in need of immediate aid. So that's what allows you to enter a piece of property and search it initially without having to obtain a search warrant, because somebody was in need. You had a exigent circumstances, if you will, to enter the property. The murder scene exception created by Arizona is inconsistent, though, with the 4th and 14th Amendments, and as such, an exhaustive and intrusive search of the crime scene without a warrant was found to be unconstitutional. So, again, when in doubt, go get a search warrant. You can do an kind of an immediate, non-intrusive entrance or pass through the residence, walk through in order to see if you're going to need to get a search warrant. But in order to really do that exhaustive search necessary to process a crime scene, either consent should be given, and it probably ought to be given in writing, or you're going to have to go get a search warrant for sure. So when can police search for, what can police search for on premises where a serious crime has recently occurred? You may make a prompt warrantless search of the area to see if there are other victims or if the killer is still on the premises, so you can make sure that nobody's bleeding and needing or the suspect isn't hiding on the scene. You may seize evidence that is in plain view during the course of whatever your emergency activities are. So if you're searching for other victims or a suspect and you find a piece of evidence that is in plain view, that is seizable at that point without a warrant. Now, the duration of the search is a factor in determining the reasonableness of the search. I don't think you're going to be on the scene for an hour and a half looking for suspects and other victims. That should be done fairly immediately upon arrival. So the longer you stay there, the less reasonable a warrantless search would be. So keep that in mind. Thompson versus Louisiana is another good case to look at. The duration of a search at a crime scene residence may cause the search to be considered unreasonable, and that's basically what I just said. The Supreme Court held that the search was not limited to looking for victims or if a killer is still on the premises, but instead was a general search for evidence of a crime. When there is a general search, then a warrant is required. So if your search goes beyond looking for victims or suspects, after your initial entrance into the scene, you're probably going to have to go ahead and get a search warrant. That's just, again, when in doubt, obtain a search warrant. That's just something that's probably just going to be necessary to do. When can police search premises that they have lawfully entered? You may make a warrantless search of premises in 3 instances. Incident to a lawful arrest. The police may search the area where the arrestee has access. So that's basically the wingspan area or area of immediate control of a person that you've arrested out of that scene. You have the ability to search that immediate area to make sure that they haven't hidden something or there's not something there that could potentially hurt you. Number 2, you may perform a cursory search of the immediate area near the site of the arrest to see if anyone is hiding. Maybe there's other people that are trying to avoid arrest as well. If that is the case, then you have the ability then to do a cursory search, not a very intrusive search, but a cursory search of the immediate area near the site of the arrest. And number 3, a protective sweep of the residence to check for threats to the police. Now, when I say a protective sweep, I'm talking about looking for people who may be hiding with weapons or seeing if there is any weapons visible or anything that could hurt you visible to you. You can't be going and opening drawers and looking in refrigerators and stuff like that. That would be considered an intrusive search and would violate that person's expectation of privacy, a legitimate expectation of privacy in a residence. U.S. versus Hassett talks about the protective sweep. It says a protective sweep is permissible only if police lawfully enter a residence. If you unlawfully enter a residence, a protective sweep is not a good search. Anything you find would probably be deemed inadmissible in court. This case also said that the police cannot create the risk in order to enter the location and search. You can't manufacture the risk. It has to be a legitimate reason for you to lawfully enter that property. For example, if you get a call that nobody's heard from somebody in a residence for several days, you get there, and let's say you look through the windows all around the house, and you don't see anything amiss. You've knocked on the door, you don't get an answer. Maybe you found a phone number, you call it, you don't get an answer. But everything you see from outside appears to be on the up and up. You would not have a legitimate, reasonable purpose to make a forced entry into that residence to see if there's anybody injured or dying or dead in there. However, if you look through the window and you see somebody lying on the floor, yes, at that point you could forcibly enter the residence and perform a protective sweep after you have seen about that potential victim. So a true protective sweep is to safeguard the officers in pursuit of an otherwise legitimate purpose. Make sure that nobody's going to step out from a closet and shoot you in the back of the head while you are rendering aid to some victim on the floor. You can't just enter somebody's house because nobody's heard from them. That's when you have to go through other means, like finding a family member or somebody that has a key and is willing to open the door for you and check to see if anybody is actually hurt in a location that you cannot see in the residence. Hopefully that makes sense. U.S. versus Santana is an interesting case as well, since the court held that retreating into your home cannot thwart an otherwise proper arrest. So basically, if the police are trying to arrest you, you can't just simply go into your house and say, nah, nah, boo, boo, you can't get me. They can. That's called a hot pursuit or a fresh pursuit. hot pursuit, in the immortal words of Sheriff Roscoe P. Coltrane. Yes, you have the ability to follow somebody into their house or go in their house and get them if they have retreated into that residence while you were trying to place them under arrest. If the police have probable cause to believe a crime has occurred, they can use hot pursuit to follow the suspect into the private location. Scent evidence from a crime scene. Identification of the suspect may be made from clothing, blood, or bodily fluids found, and a tracking dog can be used to follow the scent of a suspect. So if you have a legitimate reason to enter the scene, you can bring the dog in there, like a bloodhound or something, in order to see if you could pick up the scent of the suspect, and then you have the ability to then follow that dog, who is then following the scent to try to locate the suspect. Scent evidence can be used so a dog may follow the trail, identify the suspect in a scent lineup, and that's basically where you may have several people there, and the dog will alert on the one whose scent that he recognizes from the crime scene. You may place the dog may place a suspect at or near the scene of the crime. And the dog's alert will then establish probable cause for arrest or a search warrant, and the dog can also locate missing people using scent. So that's good to know. It's good that we can do that, because a lot of cases are solved that way. Obstructing, altering, or rigging a crime scene. It is a crime in every state for a person to obstruct a law enforcement officer in pursuit of an investigation, including evidence at a crime scene. And this can occur when the defendant alters a crime scene, plants physical evidence, or rigs a crime scene to make a crime resemble an accident, or to make an accident or a suicide resemble a crime. Either way, if you have tampered with a crime scene, or if you come across a scene that has been tampered with, whoever did that can be arrested and punished. And in some states, I believe that it is a felony. I remember reading about a case several years ago where a guy had died in an autoerotic death, and basically what that is a guy was pleasuring himself while also depleting his ability to intake oxygen by putting something around his neck and strangling himself, while at the same time he was engaging in the self-pleasure. Some people do die that way, and I've never personally seen one of those cases, although I have talked to some people who have, and they're really freaky, for sure. But a family member found the person and saw that what the scene looked like, and had an idea that they believed that it was an accidental death. So instead of just calling the police and leaving the scene as it was, they pulled the guy's pants up. They took the ligature out from around his neck and disposed of it to make it look like, hey, we don't have any idea what happened here. This person's just dead, and we'd like to know what happened. And so the police came, they investigated, they determined that, hey, what it looks like isn't what happened, because things aren't adding up, and they finally got the person to admit that they had altered or rigged the crime scene to make it look like something other than it was, and so that person was eventually charged and convicted. I don't think they went to jail or prison, but they had a fine and a conviction on their record for tampering with that crime scene for their family members. So keep that in mind as well. Protecting and searching a scene. The first officer to arrive at the scene of a crime automatically incurs the serious and critical responsibility of securing the scene from unauthorized intrusions and protecting it from contamination, and providing evidence, proving evidence is genuine and authentic, and to show the object is what it is claimed to be. So when you're the first person who's on the scene, your first duty is basically to render aid if necessary. And if no aid can be rendered, or it's not necessary, i.e. the person is already passed, then you have to secure that scene and then wait for help to arrive in order to search it. One person cannot adequately secure a scene, protect it from contamination, and search the crime scene. You need multiple people there for that. But the first officer has the responsibility to make sure that that scene has been secured and that they're protecting against contamination. That officer would have to be able to identify the object by a serial number if the serial number is on the object, identify the object based upon personal knowledge and observation, or if the evidence is not readily identifiable or susceptible to alteration by tampering, substitution, or contamination, the party must establish a chain of custody. And what that means is you create a paper trail of who all has handled that evidence and where it has been stored from the time it was collected until the time it goes to trial. If there has been a break in that chain of custody, that evidence could potentially be considered inadmissible in court because, not because it has been tampered with, but because it could have been tampered with. You may not know if it's been tampered with, but the simple possibility that it could have been tampered with will likely render that piece of evidence inadmissible at court. You have to be able to prove who had it, where it was stored, where it was, etc., etc., etc. So to use physical evidence in a criminal civil trial, the party offering the evidence has the burden of proving the evidence is genuine and authentic. If the evidence could be subject to alteration, the chain of custody must be shown. It basically is a log. And most departments will maintain an evidence log. Smaller departments may do it via a notebook, that's maintained in the evidence vault that shows when evidence was checked in, who checked it in, what case it goes to, if who checked it out, why it was checked out, where it was sent to, such as the lab, and then you would have the lab would sign for the evidence. Then you would get the evidence back from the lab, then it would be re-entered into the vault, and then when it goes to court, you would again check it out of the vault and take it to the trial where it would be entered as evidence. If you can show where that evidence has been 24/7, 365, from the time it was seized until the time that it goes to trial, your chain of custody is not broken. But if there is some point in there where you cannot account for the whereabouts of that evidence, even for a minute, it could potentially lead to the inadmissibility of that evidence at trial. So all persons who have possession of the evidence must appear as witnesses to testify the evidence had not been tampered with, substituted, or contaminated while that witness had custody and control of it. A chain of custody is not required if the object to be used as evidence is not subject to alteration by tampering, substitution, or contamination. I will say this, when in doubt, maintain the chain of custody for every piece of evidence because it's good practice. And if you do it for everything, you will do it all the time for everything. It will become second nature. So, I really don't think that you need to be trying to think about what to maintain a chain of custody of and what not to. When in doubt, kind of like get a search warrant, when in doubt, maintain the chain of custody. It doesn't take that much extra work to do that. Okay, you can read over these next several slides in regard to fingerprints as evidence, proving that they were impressed at the time of the crime. It's pretty straightforward, and you can read about trace evidence in the text as well. What I really want to talk about was that chain of custody and the issues with the crime scene. So that's pretty much it for this week. If you guys have any questions, problems, or concerns, please reach out, and I'll see you next week in the next video. Have a good week. Bye-bye.